All right. Looking at what you submitted, not entirely satisfied that it is in the language that is appropriate, but what would you think of this in terms of what I have written? Take the first paragraph. The defendant has the constitutional right to present evidence that another person may have committed the crime. Defendant may introduce evidence tending to show another person committed the crime or had motive, intent, and opportunity to commit it. And then add, in this case, the defense has presented evidence that another person, Alexander Bradley, committed the crimes charged. And then alter the second paragraph to read, evidence of a third-party culprit, so-called, must be relevant and have rational tendency to prove third-party culprit defense that the defense raises and cannot be remote or speculative. Commonwealth doesn't have the burden of proving no one else committed the crime, but the Commonwealth must prove beyond a reasonable doubt that this defendant committed the crime. And then adding language, Mr. Sullivan, however, you may consider evidence that another person committed the offense in determining whether the Commonwealth has proved its case beyond a reasonable doubt.
Sure, I do have some concerns about the language.
You've heard evidence that Alexander Bradley committed the crime. I don't really know what evidence they've heard that Alexander Bradley committed the crime.
In this case, the defense has presented evidence that another person, Alexander Bradley, I suppose I can put in, may have committed this crime.
That's a little more appropriate.
That's agreeable.
Okay. With that addition, which provides, as you say, some context, is that satisfactory?
Yes, sir.
All right, I will add that language.
The second, and I won't belabor, we talked about it at sidebar, but we would reassert the need for an independent mere presence instruction, particularly in light of the government's closing, where at the very end they insisted that the evidence shows that Mr. Hernandez is in the car. In this jurisdiction and every jurisdiction across the country, the fundamental rule is that mere propinquity to a crime in and of itself is insufficient. That is to say, the mere presence is constitutionally insufficient for criminal liability to attach in and of itself. And that's why we're asking for a mere presence instruction, notwithstanding that it's a piece of an existing aiding and abetting or joint venture instruction in Massachusetts. We wouldn't want the jury to be confused that because the government said Mr. Hernandez was in the car, that he was, by virtue of that, a culprit.
All right, let me think of where I might insert that. I will give that some thought.
All right, very well. May I hand the court our suggested language?
You may. Is it what's already been submitted as part of your request for instruction? I have it.
Very well.
Okay.
The other, Your Honor, and this is with our material too, we label it, and it is a little clunky in the labeling, insufficiency of evidence of post-crime assistance to warrant a guilty finding for a crime. The government spends a good bit of time talking about secreting the car and so forth, and to the extent that we want it to be clear to the jury that he's not being charged with an accessory after the fact type crime, and they can in fact believe that he secreted the car or disposed of cell phones and nonetheless be not guilty of the charged crime.
Okay.
And the last two, Your Honor, are we labeled them two possible inferences and other bad acts by defendants. With respect to the former, that if the factual situation gives rise to two equally reasonable inferences, one favorable to the government and one favorable to the defendant, then you're required to give the defendant the benefit of the inference favorable to him. That we submit as a fundamental concept in the criminal law, and we would ask Your Honor to consider it.
Okay.
And finally, just in terms of additions, would be the other bad act evidence by Mr. Hernandez, and this just works to clarify, just for the record, I'm handing copies of each of these to the government, clarify to the jury that there has been evidence of other bad acts, but that they may not substitute that evidence as proof that the defendant has criminal propensity.
I have
character
that.
evidence. I'm sorry, Your Honor.
I have that.
It is, Your Honor, and we just asked Your Honor to consider it in a separate charge so that it's not
I see.
buried, and we submit on those. There are a couple issues with respect to what Your Honor has, if I may.
Here, give me
very briefly.
the page, if you would.
Yes, sir. So first on page 16, this is with respect to expert witnesses. And in the 1-2-3 paragraph, the description of Jamie Downs, a forensic pathologist who reviewed materials and gave opinions
Yep.
regarding the circumstances and so forth. Mr. Furtado had a broader scope of testimony, and
You mean Dr. Downs?
I'm sorry, yes, Dr. Downs, a broader scope of testimony, my apologies. We would ask the court to include the other areas that he
Which are what?
testified to. And Ms. Kincaid,
Yes.
if you could help us with the other
We're trying to
areas.
look up the case actually, Your Honor. In the prosecution closing,
No, other areas that Dr. Downs testified.
oh, I'm sorry. Dr. Downs testified to the trajectory of the bullets, the angulation of the bullets. Dr. Downs testified as to the interval to death, Mr. Diabreu. Dr. Downs testified to the necessity of the shooter position.
Yeah. Aren't those all circumstances surrounding the deaths of Mr. Diabreu and Mr. Furtado?
I thought I read in the charges yesterday, Your Honor, that there was more specificity when it came to delineating the prosecution's expert witnesses, that they had areas that they testified to.
Very broadly.
The number of bullets was in Mr. Haig's, for instance. Dr.
Yeah.
Downs addressed the number of bullets also. So that if you're going to make it generic, I think it should be generic for all, as opposed, but if we're going to specify that it has to be specified for all, that would be our request. And we have no problem making it generic for all. They all testify to circumstances surrounding.
Yes, understand what I'm doing here. I'm certainly not commenting on any of the experts. I'm trying to remind the jurors as to who this instruction might apply to. And instead of just giving 15 separate names without any context to them, just trying to remind the jurors who they were.
Then perhaps we should take out the specificity with regard to Mr. Haig and just put in more generic with regard to everyone. That Mr. Haig, for instance, Mr.
No,
Haig
because that's the essence of what he was here for, what he was talking about. But I will add, as it relates to Downs, who reviewed materials and gave opinions regarding the circumstances surrounding the deaths of Mr. Diabreu and Mr. Furtado, including opinions regarding the number of gunshots and path of travel. The number and path of travel of gunshots. Does that satisfy the defense concern?
That would be fine.
Okay.
On the
Mr.
next-
Sullivan.
Thank you, Your Honor. On the next page, page 17.
Yep.
First paragraph, first full sentence, these witnesses include Sergeant Detective Witherspoon,
Yeah.
etc. We don't have our expert, Mr. Jacob Green. If the court could include...
Absolutely. Was that Green with an E on the end or without?
Without.
Okay. Yep, I'll add his name in after Latham.
And just briefly, Your Honor, on Sergeant Laham, it should be Timothy Laham is the first name.
Well, who's Bruce?
No, thank you.
All right. Mr. Sullivan, what else?
Yes, Your Honor. Page 53 on the intimidation of a witness instruction.
Yes, sir.
The third element, the Commonwealth to prove that defendant's conduct and so forth. I noticed in the first and second element, the concept of proof beyond a reasonable doubt is expressly stated in both. We would ask Your Honor to consider including it in the third element as well. There is a general statement below it, but we do notice with respect to first and second, it's explicit there.
Okay. I'll add that.
And there was one more. Oh, yes. I almost missed one. Page 6. And this is the last one with this on this issue. The very first sentence, during the trial there was a reference to a separate investigation involving the defendant in June 2013.
Yes, sir.
So my memory is that there was a testimony of an investigation that resulted in a search of a home. My memory is not that anything came in evidence that there was a separate investigation involving the defendant. We would suggest something along the lines of, to the extent there was any reference to a separate investigation in June 2013, comma, that evidence was admitted solely insofar, and then the rest of the sentence.
I'm sorry. Give it to me again.
To the extent there was any reference to a separate investigation.
Where would that add?
I'm sorry. So instead of during the trial, there was
Yeah.
So scratch that and scratch involving the defendant. Essentially, is what I'm getting at. To the extent there was any reference to a separate investigation in June of 2013, comma, that evidence was admitted solely insofar as it explained or was relevant to the police investigation in this case and for no other reason. So keep the rest. And so essentially I'm asking you to exclude involving the defendant. I'm not sure that came in evidence, and if it did, we wouldn't want to point to a separate investigation of Mr. Hernandez. And then there's one global issue with the instructions I want to bring to the court's attention. First day of trial in open court, the court told the jurors that each juror would have an equal chance of serving on the jury, and each juror would have an equal chance of being selected as an alternate.
Yep.
Last night when we read this, we see that Your Honor has chosen a foreperson, which would exclude that person from the possibility of being an alternate. That's inconsistent with what the court represented to the jury on the first day, because now that person will not have an equal chance of being an alternate. Indeed, no chance of being an alternate. So we would ask the court to consider engaging in the process that the court articulated in the beginning and draw the names and then choose a foreperson.
All right. My practice is to choose the foreperson before drawing alternates. which is what I've done in other cases and would do here. But I'll note the objection and preserve it.
Right. We'd like to, I don't have to play it, we'd like to put on the record that we can provide a disc or whatever the mechanism is of Your
That
Honor's. We'd like to put on the record Your Honor's statement.
It
to
is on the
jury
record.
The first day.
It is on
as
the
an
record.
exhibit.
It's on the record.
All right. So the brief indulgence. We also note for the record our objection with choosing that particular juror, that with a jury that is overwhelmingly minority and ethnic, this court chose one of two white women to be the foreperson and to ensure that that individual sits on the jury. We would state that in an overwhelmingly ethnic and minority jury, that each of those ethnic minorities has the ability, the capability, the intelligence, and the competence to serve as foreperson. And for Your Honor to make that decision has extraordinarily troubling racial overtones that implicates Mr. Hernandez's due process rights. And to the extent that Mr. Hernandez is prejudiced by that, that in fact is a ground to challenge the selection of the foreperson under Massachusetts law. So we'll note for the record that that there are only two non-minority women on the jury, in the jury pool, and this court has chosen one of them for the foreperson, and that is contrary to the express process that this court laid out on the very first day of jury selection.
All right, your position stated.
And there are four objections we'd like to preserve with respect to the closing argument. The first is that the prosecutor used the term red herring to describe the argument of defense counsel. We submit that that is improper argument. It constitutes reversible error. I have seen it in other jurisdictions. I didn't know that the prosecutor was going to use that term here. I have not researched it in Massachusetts, but I've seen that characterization of defense counsel's argument in other jurisdictions be found to be reversible error. That's first. Second, there was an objection to burden shifting when Mr. Hagan had the list. It was called defense arguments, and he started going through a list of what defense arguments were made and what were not made, and he made a comment about opening statement, and then a red line would go through on the screen suggesting that that has not been proven by the defense. Your Honor called us sua sponte to sidebar, and
Are you objecting to that?
we are objecting to what happened next. And at sidebar, as the record will reflect, Your Honor said that was improper argument. When the Commonwealth came back, it continued with the slide, though without commentary, in full view of the jury, with each claim and a red stripe going through it. This is the precise argument that the court said was improper, and the jury saw it, the jury read it, and the words on the screen are just as injurious to Mr. Hernandez as if the words had come out of Mr. Hagan's mouth. So we object to that as well as burden shifting. Third, Your Honor, we renew our objection with respect to the tattoos. Your Honor, in his written order, stated that the tattoos come in for consciousness of guilt. We briefed extensively the issue of the tattoo as an admission. And I'll state it briefly here that there is no case ever in the history of Massachusetts that has allowed a tattoo to come in as an admission. And the reason is because it has profound constitutional implications with respect to the Sixth Amendment. There are only a few cases nationally, which I've discussed with Your Honor, in the leading case out of California that I won't go into today. But the court allowed the Commonwealth to characterize this not as consciousness of guilt, but as an admission, as a confession. And we submit that that is constitutional error of the first order. It's improper, and it is supported by absolutely no Massachusetts law. For all these articulated reasons, at this point, we move for a mistrial based on the cumulative impact of the error and the prejudice that Mr. Hernandez received, red herring, selection of the foreperson in the jury in contradistinction to the court's express process, the ignoring the objection to the burden shifting about the defense's arguments and the use of the tattoos as admissions.
All right, the motion for mistrial is denied, but your positions are stated on the record and preserved. All right, counsel, jurors should be back with us at 2 p.m. Oh, I'm sorry, Ms. Anderson.
Your Honor, briefly, I can go to the jury instructions.
Yep.
Unless I don't think any argument on the closing argument.
What?
Page 13, the instruction on the grant of immunity. With the second sentence of there must be some corroboration of the witness's testimony as to at least one essential, turn the page, element of the crimes or crimes charged. I just want to make sure that that instruction is clear, that that amount of corroboration is minimal. The Dabrowski case that sets out the standard says the statute requires corroboration only as to one element of the crime charged.
As to at least one essential element of the charged crimes. I think I say that maybe in different language, but...
And I think the word only, to make it clear, only as to one essential element would make it extraordinarily clear.
All right, I will think about that.
Page 20, the consciousness of guilt instruction. In
Yep.
addition to the dates listed for the crimes, the Commonwealth would request, and as it did in the original submission, that the date the defendant obtained the tattoos in California, either generally just after February 13th, or a date of late March or early April.
No. And only because I try and stay away from commenting on the evidence. The dates of offense are established, but I'm not sure I ought to go into other dates.
Finally, in the witness intimidation instruction, we talked about yesterday including the last part of the statute. I think the way Your Honor has written in the instruction, it's very clear that the crime is under Massachusetts law, what the Commonwealth is alleging here as to the shooting in Florida. But if we wanted to go one step further, I think in addition to quoting the language on page 52, as to what the charge, or as to what the indictment prohibits, that the additional language from the fourth section could be included.
Which is what? I don't have the statute in front of me.
A prosecution under this section may be brought in the county in which the criminal investigation is being conducted or in the county in which the alleged conduct constituting an offense occurred.
I'm sorry, give that language again.
Certainly. It's section 4 of the statute. A prosecution under this section may be brought in the county
Yeah.
in which the criminal investigation, comma, grand jury proceeding, comma, trial, or other criminal proceeding is being conducted or took place, comma, or in the county in which the alleged conduct constituting an offense occurred.
And what's the advantage of adding that?
I think just to address the concern that we all had yesterday, that the jurors not misunderstand that the charge is appropriate here, that there is jurisdiction.
Well, I
over
tell
the-
them that in the last paragraph.
I agree, and your Honor's instruction includes the names and goes well beyond what the Commonwealth proposed, and I think that's appropriate, and I think that does help to clear it up.
Seems to me Section 4, as you've referenced it, is more jurisdictional as a matter of statute than it is part of an element the jury ought to consider.
Certainly.
And I'm satisfied that I've made clear that in the last paragraph as to the application of this statute to the facts here. So I'm not going to make that change. Anything else, Ms. Anderson?
No additional additions. I would object to the 5 requests that the defense just made. I think, again, mere presence, that supplement is taken out of context, and the no accessory type charge is also not necessary. I think that's covered in Your Honor's instructions on the elements of murder, on the elements of the crimes charged here. The request to give the defendant a benefit of an inference, I don't think is appropriate. I think Your Honor's instruction on inferences covers the appropriate way that the jury can use the evidence and build inferences. And I don't think another bad act instruction is necessary as it's covered in these instructions.
All right. I likely will reference that the Commonwealth must prove that the defendant committed the crimes charged by conducting or performing the acts necessary for the completion of those crimes, or something along those lines. Merely being present at a location where someone else committed a crime, standing alone, does not prove one's guilt beyond a reasonable doubt, nor could participation after a crime in disposing or concealing evidence, standing alone, prove one's liability or culpability for the charged crimes. That's in essence, paraphrasing, I think, Mr. Sullivan, the two concerns that you have. And I don't think offend the legal instructions I'm otherwise giving. So I likely will put that in somewhere. I don't quite know where.
That's agreeable.
All right. Council, we will resume at about 2 p.m.